number 118527 in the matter of Linda S. Trigg, respondent. Counsel, before you start, two things. One, is Linda Trigg in the courtroom? Very well. The second thing is Justice Johnson is recused on the case, and sitting in his chair is the distinguished jurist to my left, 2 chairs down. This is the Honorable Peggy Carr Kittle. She's the Chief Judge of the 7th Judicial District sitting in Douglas County. She has read all the documents in the case. She'll be participating in the oral arguments and the ultimate resolution of this case through written decision. Judge Kittle, on behalf of my colleagues, I'd like to thank you for helping out the Supreme Court. Thank you. All right, counsel, please proceed.
May it please the court, my name is Todd Thompson. I am the examiner for the Commission on Judicial Qualifications. This is an original action relating to judicial conduct. The complaint in this matter was filed by the 10th Judicial District Executive Committee, a happenstance that has never occurred before. It arose from a probation violation hearing conducted in front of Judge Trigg back in September of 2016. And because of the import of the happenings at that hearing, I'm going to quote the hearing itself. The court called the case. The defendant identified herself as being present. The court then said, "Show Mr. Andrews for the state. Defendant appears in person, in custody, pro se. There's a motion to revoke your probation for failure to comply on file for various reasons. I find that sufficient. I revoke your probation and remand you to the custody of the sheriff's office to serve the balance of your sentence." That was the extent of the hearing. Judge Trigg ignored the investigation in this matter. She refused to respond to numerous contacts by me and by my office. She was not cooperative in any way, shape, or form. She failed to appear for her hearing in front of the panel, the investigation panel. She was offered a public cease and desist order, and she failed to timely accept that order. And as a result, this matter is now in front of this court. She did, however, retire and is no longer on the bench. All of the facts are admitted because there is a transcript that was admitted. That is the extent of what happened here. She completely ignored the defendant's right to counsel. She received absolutely no evidence other than to acknowledge an affidavit in the motion having been filed, and the defendant was immediately remanded to custody. I don't really have a lot to add to the judge's behavior.
Counsel, could you address what sort of notice was provided to her to know that she would be the subject of today's hearing?
I can do that, Your Honor, and I'll also comment that the one item she did do was to acknowledge by an email that she was aware of the hearing in front of the disciplinary panel and that she was not going to attend. She simply did respond by saying, "I won't be there."
Was that before or after the retirement?
That would have been after the retirement. She received from the secretary or the clerk of the appellate courts a certified copy. She signed for that, so she did receive notice of this hearing today, and she's just not here.
Is it fair to say the only communication that your office has received has been that October 2017 email from the respondent saying, "I know the hearing is tomorrow, but I will not be there"?
Correct. Well, except she did sign for the letter that the clerk of the court sent to her about today's hearing.
All right.
She signed also for the receipt of the cease and desist order that was proposed.
She had a retention election and then retired shortly after.
No, she was the magistrate in Johnson County, and
Well, I thought there said something about a percentage of vote that she received.
I'm not, no,
Okay.
that's not
Well,
true.
okay, then, when did she retire then?
She retired on March 20th of 2017. This complaint came in the fall of 16. She immediately announced that she would be retiring on March 20th of 2017, and Judge Moriarty thought that was an appropriate solution. He put her on limited duty for the remainder of her service, and she left office then on March 20th.
The findings of fact from the panel indicate that regarding the cease and desist order, that she refused to accept the order. Is that the same? That seems inconsistent with your statement that she signed for it. So if you could clarify that.
The rules provide that when a cease and desist order is sent out, the respondent has 20 days to accept that order or can refuse the findings and directives of that order. It also provides that if you fail to respond within 20 days, then that shall be deemed a refusal to accept the order. And she failed to respond within the 20 days. So it's deemed that she refused to accept that resolution of the case.
She signed for it, but did not follow up.
She
Therefore,
received the certified mail. She did not respond to the order itself after presumably having looked at it.
right. Any further presentation?
I have no further presentation. I will answer any questions.
Was there any explanation as to, I mean, it doesn't appear that any explanation at all for her conduct at this particular hearing or during this period of time?
Her conduct was explained to Judge Moriarty, who went and saw her after being advised of the situation, that she just wanted to send the defendant a lesson.
Okay. And do you know if she is practicing law at this point?
I do not know if she is practicing law. In light of her response to this investigation and her disregard, frankly, for the judicial system, I certainly hope not.
But we don't know, or you don't know.
I do not know.
Okay, thank you.
Any more questions?
The panel recommended that the respondent be disciplined, right?
By a public cease and desist order, correct.
And is that your recommendation here as well?
Rule 623 provides this court with very broad authority. I think the exact language is that you can enter such other disposition as justice may require. I do not believe that Ms. Trigg has shown a respect for the court system that should allow her to either practice law or ever serve as a judge again.
And I guess that gets to my substantive question that I want to ask, which is the respondent's not a judge any longer. Within the confines of this proceeding, do we have any authority to actually mete out discipline on a non-judge?
I believe this court determined in Ray Henderson that it does still have authority over judges who retire after a complaint is filed against them.
If I recall correctly, which I might not, in that case, the disposition was along the lines of all the facts that were found below are true and they're made public via this opinion, but because the respondent in that case was no longer a judge, there was no discipline to be meted out.
I believe that's correct.
And so I guess the question is, do you think we should follow that path here? Do you think we Or do you think there's another path available to us? And if there is another path available to us, what would be your argument in favor of us taking that other path?
Well, one other path that is available is for this matter to be referred to the disciplinary administrator so that the respondent's license to practice law could be removed in light of her, frankly, disdain for the judicial system and this proceeding.
That wouldn't happen unless and until, as someone who holds a license to practice law, the respondent was afforded all the due process protections and goes through the process under the disciplinary administrator. So
Correct.
You're not suggesting that we would sort of preempt that or shortcut that process?
I am not, no.
So is there any other kind of discipline that we could actually mete out in this case? That's what I'm struggling with, and we obviously struggled with that in the Henderson case.
The term discipline is actually defined in the rules, and it does not allow for any other option that can be considered here besides a cease and desist order and a recitation of the facts and the...
I'm sorry, I'm interrupting you. Go
Okay.
ahead.
Then there is that catch-all clause, though, later on, that provides for the court to impose something to accomplish justice. It's not going to be, quote, discipline, because it's not within the rules definition of discipline.
And you're not proffering any opinion or guidance to us on what you think that might be.
Well, for example, I do think that under that broad definition, the court has the authority to direct that a person not be a judge in the future. So that would fall within a disposition that justice may require in this case, and I think that would be quite reasonable.
Given that you still have a little time left, can we explore that road a little bit?
Do we have to?
Well, that's an outcome that's been suggested in cases you just suggested it, and I think it's been suggested in other cases, and I'm just theoretically trying to figure out how this court could have the authority to bar a citizen from holding a public office in the future. That's a big step to take, and I'm not even suggesting that it may not be justified here, but what I'm trying to figure out is the contours of this court's power to impose that outcome. Where do we get that power from?
Well, all of the rules and regulations which forced retirement, which is provided for in the rules.
Those all apply to judges.
Correct.
And that's clearly there, and it's in our Constitution. The power to remove and discipline judges is set forth in our Constitution. But that's judges. We're talking about somebody who's not a judge.
Well, but a designation that an individual has shown themselves not to be fit to be a judge, and this court's obligation to protect individuals from being thrown into jail without their due process rights even being considered or shown a shred of respect, then we're talking about a point in time at which a person would become a judge. And I think this court should have the authority to say, no, you've already shown yourself.
Wouldn't we have to wait until that person became a judge again and then initiate those disciplinary? I understand the competing interests, and I think they're both strong interests, but I'm struggling with the idea that we can tell a citizen, we have districts in our state in which a person can stand for election to the judge, and we're saying you can't do that. We're saying this person is not eligible to stand for election to a public office. And you see where I'm going here.
I see the dilemma greatly, but the flip side is, knowing what you know now, do you have to wait and allow that person to take the bench and to have control over the citizens of this state, and then to again go through a due process procedure that they've ignored once and shown utter disdain for, how is that serving the individuals who are harmed by the wrongful conduct of the judge? Because at that point, they would be a judge.
Thank you. I appreciate you being willing to walk down that theoretical path with me.
Counsel, I wanted to go back to a statement I understood you to say that the commission's discipline that they suggested was a cease and desist order. I'm looking at the November 1st, 2017 report, and it appears to say that they recommend to the Supreme Court that the respondent be disciplined for the violations by public censure.
I'm sorry, that's correct.
Okay. Looking at just that narrow issue right now, what is your view on whether we have the authority to do even that? Because as you and Justice Stegall were talking, she is no longer a judge. Do we have the authority to impose that discipline under Article 3, Section 15 of the Kansas Constitution, which authorizes us to discipline, but it also says judges? So do you have a view on that?
A public censure is, as I think was recognized in the Henderson case, a comment by the court on the behavior of a person who was a judge at the time of the behavior.
Okay, now, we did not issue a public censure in Henderson. I have the opinion here.
But a public censure is a comment on the behavior of an individual when they were a judge. So you're not making a comment on the behavior of a person who is no longer, they may no longer be a judge, but you're still talking about their behavior while they were a judge. And if this panel recommended public censure, that's what they're, I think, suggesting be done here, is that the behavior of Judge Trigg be condemned by this court, or that she be censured for that behavior.
Which your position is we have the authority to do that for somebody who's no longer a judge, for actions that she took while she was a judge, is my question.
I believe so, yes. If you're asking if that is my interpretation, yes, I think that's a very reasonable interpretation.
And to go back to what I understood you to say earlier, are you saying in conjunction with that, or even in lieu of that, you believe that this court could forward this information to the disciplinary administrator for attorneys and say, here is the information, do with it what you will, and then if that proceeded, now Attorney Trigg could be subject to that whole process?
Yes.
Any more questions? All right, thank you, counsel.
Thank you.
Court will take this matter under advisement.